The judge, who presided over former President Donald Trump's 2020 election indictment, denied his request to hold Special Prosecutor Jack Smith in contempt. Earlier this month, Trump's lawyers called for Smith's team to be held in contempt of court, even as Judge Tanya Chutkan stayed additional proceedings pending a challenge to the president's immunity. Thus, the key dispositive sentence of the suspension order does not, of itself, clearly prohibit the government from voluntarily, but not necessarily, complying with the time limits set forth in the suspension order, Chutkan wrote in the opinion. Trump's team noted 3 significant motions Smith filed after Chutkan ruled in December that any further proceedings that would take this case to trial or impose additional litigation burden on the defendant would be stayed. Despite Trump's refusal to punish Smith, Chutkan still granted him a partial victory by clarifying her order of tenure. Until the mandate is returned in this case, the parties shall not file any substantive pretrial motions without the prior leave of the court, and any such request for leave shall state whether the proposed motion addresses issues on appeal or instead is auxiliary to it. She decided. Trump's team quickly prevailed over Chutkan's opinion. The D.C. District Court issued a strong condemnation of the deranged Jack Smith, enjoining him from pursuing President Trump with additional claims and forcing him to comply with the stay order in the J6 case, Trump campaign spokesman Stephen Chung said in a statement. At the heart of Trump and Smith's dispute over court documents are concerns about the trial's March 4 start date. Smith unsuccessfully asked the Supreme Court to expedite Trump's presidential immunity argument and overturn the indictment currently pending in the D.C. Court of Appeals, but the High Court declined to do so. Prosecutors appear to want to keep the trial's March 4 start date amid largely unspoken concerns that as Trump gets closer to the election, it will become more difficult to convict him. While Chutkan did not reveal plans to change the trial's start date, she appeared to briefly hint that such an adjustment might be necessary. Contrary to defendants' contention, the court has not and will not impose time limits in this matter based on the assumption that he undertook preparations when he was not required to do so, she wrote. In other words, Chutkan suggested that Trump's legal team is not required to bear any meaningful burden while the proceedings are on hold. She also noted that if and when the mandate is returned, the court will set a new timetable. Several key trial dates have already passed and others are in jeopardy. For example, potential jurors are expected to complete forms by February 9, less than 3 weeks. Trump has pleaded not guilty and denied wrongdoing in the 4-count indictment against him in the 2020 election, as well as in 3 other cases.